What is your opinion on what's getting better for divorcing fathers? The law is so balanced right now. I started practicing law enough decades ago to know that this has been a huge shift in the law over the course of the last 30 something years. Initially, mothers were highly favored around child issues, and fathers were really treated like visitors, and we gave them what we called visitation. And now the law is that we are to maximize the parenting time between the parents to the extent that we're able. And that is such a nice thing, really, for both parents. So that's when we will take a look at what the historical parenting has been, and that's going to speak largely to what it ought to be going forward. And if you have been a really involved dad or a really involved mom, then that's probably going to be reflected in the parenting schedule going forward. What are your three best mediation tips for spouses? Number one, stay open-minded. There's no perfect solution to any particular case. There's a range of solutions. You just want to get in the range of what the court is likely to do, given whatever the facts of your case are. Number two, remember that you're still going to be a family. You're just redefined, but you're still a family, and make your decisions and choose your words and your actions accordingly. They matter, and they will continue to matter. And number three is to trust this process. This process is tried and true. It is a highly successful process. And it's painful to watch those, and luckily it doesn't happen often, but those who come in and fight the process, either because they need to control it or whatever, because those actions actually make it harder for this process to work. The process itself, when well handled with a decent mediator, will take care of you. What are your three best divorce mediation tips for family lawyers? Number one, don't set your client's expectations too high. You hurt yourself when you do this if you can't meet those goals. You become a disappointment in your client's eyes. And I can't tell you how many times I've heard, but you said X was the minimum we were going to agree to. And you may have said that at a time when the facts look like that was warranted, and then in the mediation, more facts come out that have you change your mind. So that mind changing is a really important element that benefits a client, who is then saved from going to a litigation slaughter based on faulty information that wasn't had initially. And yet this client will feel it as almost betrayal. So I think it's really important to cage whatever it is you say to a client with what we know right now, with what we know today. This is what I think we ought to be doing, but we're going to stay flexible. If you can stay in that vein, no client's ever going to be disappointed with you. The second element is to be realistic. Be realistic about who your judge is and what they're likely to do. They are all different. They bring their own personality, their own life experience to that bench. And one judge's life experience and personality is going to be dramatically different from the next one. So what the next one has to say about your case, or what you think that next one might do in your case, is truly irrelevant. What matters is, what does the judge that your case is in front of think? And that will help you guide your client. I think also be very realistic about what kind of witness your client is going to be. If your client simply cannot maintain the stress of being a good witness, or just isn't capable of doing it, and it can just happen, good people can be bad witnesses, then that needs to affect the decision making at the settlement table. And then the third piece of advice that I'd give lawyers for mediation in family law cases is, remember that this problem is not your problem. This problem is their problem. And don't take on their problem in an emotional way or substantive way as if it is yours. It is theirs. Stay calm, stay intellectually neutral to the extent that you're able, while also advocating. But if you take on their problems as your problem, then the good advice you would normally give to someone when you're disconnected is not being given to this particular client. It's really important to take a step back. Do you have any divorce mediation tips for high conflict divorces and custody battles? Number one is, remember, this isn't your problem, this is their problem. Stay back emotionally from what the problem is so that you can clearly see what's happening and give good clinical advice on how to tackle it. Ask yourself, what is the real issue? What am I really fighting about here? What is the real argument about? Are we fighting about whether Johnny can go to soccer on Tuesdays, or are we really fighting about Tuesdays are the night that the mother wants always because there's a show on television that she's watched with these children for years, or maybe the father's done that? What's the real fight about? Or is the fight that you're mad and hurt? And we all know hurt can come out quite commonly as anger. Is that what's really going on? If it is, and you can see it neutrally, then we can address that. There are actually ways to address hurt in a mediation, not in a trial of a family law matter, but in a mediation. But what's the real issue? Separate the wheat from the shaft on this so that you can really solve what's wrong. Because until you do that, no other solutions will work on any topics. Keep in mind also that in high conflict cases and these ugly custody battles that take on a fevered pitch, the court is going to eventually figure out what's happening. And it may not be in the first hearing, it may not be in the second hearing, but as it continues on, the court is going to figure it out, and the court is going to put sort of a label of sorts on your case and on your issues. And that label might not be great. And courts can then take swift, sometimes punitive action when they get the feeling that this is just a high conflict battle because of control issues or whatever the negative issue is. So be mindful that every battle you fight, there's a price to be paid. What are some divorce mediation myths? The first myth is that the mediator is going to show the other side exactly where they're wrong. And that might happen in practice in the sense that I'm not going to let a party lollygag around out on some crazy legal theory for very long, but it will not ever happen in a way where I say to that party succinctly, that's nuts, back it up. That would just be such a rarity for something to be dealt with by a mediator that succinctly. What I'm going to do is I'm going to use questions, and the questions will be things like, Mr. Smith, I want to ask your lawyer, does your lawyer have any concern about Judge Jones actually going with this theory? And then I'm going to let it fall, and I'm going to let your lawyer answer very honestly whether or not they think this legal theory is going to fly. And that will almost, through the use of questions, almost always resolve those issues of when someone takes some crazy position. The second myth is that mediators are going to make decisions. I'm not going to make any decisions. The only decisions I'm going to make are about the words I choose to use. And those are the most important decisions, I think, going on in the day. And I'm not going to give any legal advice. I'm not going to make decisions, give legal advice, do anything that a lawyer would do. The decision making is all in the lap of the client with the guidance of the lawyer. And the mediator's job is not to force someone to a decision making position, because that's a mediator making a decision, and that's not a mediator's role. It's a client's job to do that. The third myth is that mediators take sides. I understand where this comes from, because there are times in every single mediation when one party or the other is going to feel like, well, the mediator you're in here just telling me he's doing everything right. And you just don't, you don't like me, or you're not, why are you being so hard on me? Almost always that's going on in both rooms. What's feeling hard is often what I call ghost busting. I'm going to let it the theories bounce around for a little while and the conclusions bounce around for a little while, and then I'm going to start ghost busting those, typically through the use of questions, to make sure that everybody's on a more realistic playing field. Explain the parentification of children in divorce. And in my experience, how often do I see parentification of children of divorcing parents? And do I have any advice about it? The parentification of children in divorce is when one parent looks to children either for friendship, companionship, or emotional support in a way that was probably more typically received from their spouse who's no longer in the role of spouse. Maybe they've separated, they're living in separate places. And to move children into this friendship role or comrade role or emotional support role is very dangerous for children. It's extremely unhealthy for the parent, but it is overwhelmingly unhealthy for a child. And those children who don't get relief through counseling on how to set boundaries for parents, which is very, very difficult for a child, will carry the burden of that parentification literally to their coffins. They will always feel the need to protect and help and support the parent who has constructed this. And that's not a child's job. A child's job is this crazy thing called being a child and doing what kids do, playing in the dirt, kicking the ball, going to baseball practice, signing up for the cheerleaders, spending nights at their buddy's house and having their buddies come over without the burden of having to take care of a parent. It's not a child's role. So this needs to be immediately addressed with a good child's therapist to make sure that this child gets the support that they need and learns how to set boundaries. And probably that parent needs counseling too on what this is and how to stop it if they're willing and if they're able. If they are not willing or they are not able and it does not stop, it has to be brought immediately to the attention of the court. The court will do one of a couple of things. It may address it directly itself to get it to a stop. It may order some psychological testing, some or all of the parties and children, or it may take a step and order the appointment of yet another lawyer who represents only the children, called a guardian ad litem, or it may do some combination of those three things. But it's going to have to be brought to the court's attention promptly if it doesn't stop.